come to the afternoon session of our panel discussion, where our esteemed speakers will speak on the topic of legal challenges in the digital era, cybersecurity, data privacy, and e-commerce regulations. Our afternoon panel will feature our speakers, Mr. Nikunj Savaliya, Head Corporate Legal at Bayer Corp Science Limited. Let's have a huge round of applause, everyone. Our second panelist is Mr. Manoj Gujaran, Chief Compliance and Officer at Head Legal, Poonawalla Fincorp Limited. Let's have a huge round of applause for Mr. Manoj. The moderator of this panel, Mr. Nitin Bhuwania, SVP Legal and Compliances at Easebuzz. Let's have a huge round of applause for him as well, everyone. And our fourth panelist, Ms. Nandini Nair, Global General Counsel at L&T Technologies Service Limited. Please have a huge round of applause for all our panelists.
So that's great. I was sitting right. The moderator is right place. So I think a very, very interesting topic. And it's one of the hot topic. Discussions are going around in this topic in almost all the forums which we have attended. There are entire day sessions which are happening. Before we start, I think we have made the sessions dry, so we'll make it slightly entertaining also at the same time. Thanks LexTalk for giving me opportunity to moderate this session. I'm Nitin. I take care of the legal and compliances at Easebuzz. We are a payment aggregator fintech company. So I come from a digital technology company where the technology is the core of everything. So we will talk about the cybersecurity, data privacy, and e-commerce regulation. Our esteemed panelists, which is here with us, are also the veterans in their profile. So I believe we will have a very enlightening and learning discussion on these topics. So we can start the topic with a matter of point which comes out, cybersecurity. The first thing which comes to the mind is cyber fraud. That's right. I think how many of the lawyers have been impacted with cyber fraud? Okay, I can see someone putting up the hand. Maybe and then there's someone in the another corner. We are supposed to be one of the very educated lot and supposed to be aware of the regulations very well. But when it comes to cybersecurity, even we have been duped. We have been tampered. I come from a payment company. Every day I get WhatsApps from very different number which I'm supposed to block. Call come from a different cross jurisdiction which I'm supposed to immediately block. These calls, these WhatsApp, the video calls which comes to me is how it is reaching me and how they have got my data. It's something what we should connect to each other and talk about today. We have a very renowned panelist, Nandini, who is from US and part of L&T Technology Services. So again, tech is the core. So I start the discussion with her, and the very first question which flows to her is, how do organizations navigate the evolving landscape of the cyber threats? And I spoke about few threats which is coming up, and the cyber attack. And this is an attack. Why it's an attack? Because it's a financial terrorism after all. So your money is getting duped, your profile is stalked, your data is being duped. So, and when it comes to organization level, at the org level, the query is very simple. How is it that other people are having those data, and how do we protect and how do we navigate this landscape? Over to you, Nandini, on that.
Thank you. Pleasure to be here. Yes, I am definitely from the US, so don't let the outside package fool you. I'm American mainly. It's very nice to be here. In regard to the organization, you have to have actually, first of all, a culture of understanding. Cybersecurity has been something that's been evolving. It's a constant situation for companies, corporations, multinational corporations that do work in different jurisdictions. How do you, as an organization, prepare for something like this? There are best practices, and every company should be having certain things like this. One is employee training. These are individuals who control your employees. They have the ability to bring in a hacker, be able to manipulate data inadvertently, not, on purpose. So you have to train your employees. You have to have a response plan if there is a data breach or a cybersecurity threat. You have to have up-to-date systems. One of the things that I have found working with the in-house is that as much as culturally we want to keep systems progressive and technology forward, the cost of that will be prohibitive to a lot of companies. So they will say, okay, last year's data security system is fine, but actually there are loopholes that come in. So you have to constantly update your systems and processes. You have to have an internal target plan, meaning that how do you deal with internal threats that may come through? You have to be compliant, and compliance is not something that is one day. It is every day. It's 24 hours of the day, and it's constantly evolving, keeping up to date with that. You have to have IT protocols. There's multiple different levels of things that a corporation needs to do. It is not one, it is not two, it's probably at least 50 different things that everybody has to do. And it is not a one-person thing, it's an all-employee engagement to ensure that the company remains secure.
That's great. I think learning was something important, cost, updating with the compliance, and also technology is evolving. As what was the mood which came out very clearly. So one of the important aspects of learning, what I have noticed is people act late in their life, especially when it comes to cyber fraud. They are delayed in their actions. We are a payment aggregator company. If I get the complaint within 24 hours when the settlement has actually not happened to the other side, I can hold the transaction, I can protect the victim. So non-awareness of the regulation, acting late, is something what we have noticed has become one of the reason of the complaint not getting or victim not getting a faster and speedy resolution, is something which I can talk from my experience. Rest, it need to evolve. And problem with organizations are, when it comes to compliance, it becomes a cost. Let us accept it's not a cost, it's a protection, which is must. Gone are the days when you will find a regulator coming up and telling you there is a penalty of some amount on you. This is the day when the regulator will say, stop the business. We have seen that. So from there we move to Mr. Manoj, and the question which comes to me is right now, what are the legal frameworks we have? Like, do India have those legal frameworks to protect the cybersecurity incidences? And even if we do have, how effective are they in practice? Are they actually practiced by organizations in their legal framework, or it's just something which is written on the text books and not being practiced?
Thank you. Yeah, of course. The primary legislations are IT Act 2000, which grants statutory recognition to all the electronic transactions, which prevents unauthorized data leakage, and which also identifies phishing, malware attacks, identity theft, and electronic theft as punishable offenses. Then you have IT rules, which puts obligations on all the entities to report all the security incidents to certain. And then you have SPDI rules, basically Companies Act, which asks the entities to safeguard their electronic documents and their systems. Then you have sector-specific regulatory requirements, which are regulated by, for regulated entities, regulated by SEBI, RBI, IRDA, DOT. They ask their respective regulated entities to put cyber security safeguards and processes within their entities. So these are the acts, and of course you have to practice. Gone are those days when only penalties were levied. Now there will be business restrictions. In fact, if there is a cyber attack, the data theft that may happen can lead to a lot of not only business loss, but also, a ransom money that will be required to be paid by an entity. And of course, once a cyber attack happens, then the business automatically anyway stop, whether the regulator pitches in or doesn't pitch in, your business stops for, I don't know how many months. We have seen various institutions whose systems were attacked and their business got hampered for average 3 months is what I have seen. And of course, and additionally they have to pay the ransom money asked by, you don't know who is asking the money, but you have to pay it in. So
that's so right. What I understand is like we have the regulations. There are regulations. Unfortunately, very few of them are actually being practiced in org level. And I'm boldly making that statement because that was not the core which organization used to take care of, organization look into. They used to always focus on business. It became all the tech world, and the tech world brought this tech challenges. IT Act, the incidents management reporting, certain incidents management reporting, still organization avoid to report the incidents. Why? To avoid the repercussion. We have, and again I'm repeating, regulators have understood that, and they are taking all of that into consideration now. If you have not reported incidents, it's not only your organization who has been part of that fraud or that crime, you have actually helped the entire financial terrorism which is there. And see, the regulations are there, people are not implementing it, but then how to implement it is get the organization audited. So one of the important point which became right now in the eyes of regulator is get the system audit done. Why system audit? And GCs became part of those audit, and it was surprising to me. It came to my table, as a general counsel, as a lawyer, review the system audit report. It's very surprising to me, for a GC to review a system audit report. What I actually realized when I was going through the system audit reports, and then I started into that direction, what came to my mind was the entire system audit report is trying to protect the organization from this cyber threat, cyber attack, and to avoid disputes, to have records in place. We keep records in our day-to-day life for our documentation, for our agreement, what we do. In this today's world of e-commerce, where are the records being maintained? With all good respect to everyone, a lot of people don't even know where the record of the organization is being kept, somewhere in the data, somewhere tick marked, and that statement is terms and use accepted. That terms and use acceptance is a contract, though the testing of that has to still happen in the Indian courts, but still that's a contract. The very question which come to me, and when I was reading the cybersecurity, the cyber audit report, the system audit report, does those contract have the timestamp? Do they have the IP address recorded? Who has actually signed the contract? The signature, the IP address, and the timestamp when the contract was getting signed, which jurisdiction it was getting signed. It all becomes very important, very critical. Someone sitting out in a jurisdiction which is very different, where the IT Act has a very different economic, in fact, those contract have a jurisdiction importance there itself becomes a questionable aspect. So it became very important. We see a lot of the CRM tool which are there, the CLM tool which has come up with e-signature, e-discovery and all of that, which is part of the today's world. But then those basic checks need to be there. And it used to be there in our contract. We used to mention the place, we used to mention the date. Where is that in the online contract?
And you must also ensure that the person who is signing the documents electronically is the authorized person, or is the individual basically who is required to sign an agreement. So I think the most authentic one is, Aadhaar based OTP signature. I think that needs to be ensured for any document that is electronically executed or signed by any person. I think that improves the authenticity and reduces fraud basically.
Class 2 digital signatures, use them. People are not using, scribbling just on something. Even if you are scribbling, which is called a virtual signature, please have the audit trail photograph of that person being recorded, so that becomes enough proof of you to justify that this contract was signed by this particular person and he was part of it, because everything has happened virtually. So like we are actually have to build those robust systems, those robust technology. From here, I think we should move to and take more insights from Nandini. Like how do international and laws and regulation impact the cybersecurity practices, especially in the context of cross-border data breach, which is which is happening. And her insights would be helpful because we are practicing something. Let us understand from her how the international laws and regulation impact the cybersecurity practices.
The issue actually with cross-border data breaches or cybersecurity threats is that different countries or different states actually have different laws, or they're sometimes silent on these laws, or there's different interpretations of these same laws. So it is a difficult thing to navigate when you have a data breach or cyber threat across a state line. You have to look at things in a very different light. You have to look at, first of all, what is the precedent in that specific country. Do not use your internal lens of India or the United States or Europe. You have to look at where the breach is. You have to look at where the data could have flowed to. And again, sometimes both regulations, let's say you have two different borders, two different states, two different countries that you're dealing with, they may not reconcile. So, for example, in the United States, we have different laws per state. There's 50 different states. So if we have a data breach, let's say our employee data was hacked. Now we have employees across domestic United States. Now I have to look at every single state where I have employees to understand what are my obligations, what are my requirements, what is the diligence that I need to do per state. Some states require me to notify the employee, for example, within 10 working days of the data breach. Others say 25 days. And so it is very complex. And one of the biggest things I tell to GCs, or I would say to myself, is when I've had this data breach, and I've had this here and there, is action is required immediately. Sometimes in the corporate world, one of the things I find very difficult to navigate is the slowness of the response. In cybersecurity, in cyber threats, in data breaches, there is no room to rest. The second it happens, you have to come into action. And legal becomes a critical part of solving these issues, making sure that you understand what has occurred, what are the implications, what are your obligations as a company to disclose this, whether it is, if you're a public company, for example, do you have to disclose this to shareholders? Do you have to disclose it to all employees? Or is it a subsect that you have to disclose to? This is where the GC and the legal team that you may have becomes a critical element.
So again, we come out to the same point.
Yes.
Action.
Always,
action,
always.
Action. That's action need to be in swift. And that is what I keep telling everyone. The companies are transacting on thousands and crores of transactions a day. It's very difficult when you sit idle on that. What has happened in the past, the transaction is already settled, matured. There has been layering done by the other parties, and then you are coming forward and coming up with questioning on certain transaction. So, and we have, and this is my personal experience, what I have noticed, there is a hesitation to do action. They don't have awareness. Where do they need to complain? The government is doing their part. MHA have a dedicated helpline number to complain cyber threat, cyber fraud, which is happening with anyone. People are not aware of those helpline number. People are hesitant to reach out to them. And even if they reach out, they didn't provide the entire data, entire detail. It becomes very difficult for the organization to track it. If you come after 3 or 4 days or 5 days, just imagine a situation, the 4-day, 5-day in a life of a corporate, which is into transaction banking, is equivalent to around 3 or 4 years. If I come back to you after 3 or 4 years and talk to you something about which has happened in the past, you will be like, Limitation Act is there. That's right? 3 years? There should be a Limitation Act. I always keep on telling nowadays, there should be a Limitation Act for transactions also. Because the problem is the transaction has gone very deep digger and they have been layering what has happened.
You also have to look at your indemnification clauses. I'm just going through something like that right now, and you want to ensure that if there's a breach, and let's say the vendor breached, or your partner, vendor partner for some reason, what is the indemnification provision you have in that agreement? That becomes critical, because will they be liable for all costs associated with fixing this data breach or the cybersecurity issues that you have? What happens if there's a ransomware, right? So multiple issues you have to look at.
That's right. And unfortunately, we have not seen much of the indemnity helping the organization here in India, maybe in the cross-border. And that is what the learning we need to do. We need to ensure we lawyers argue so much, fight so much for an indemnity clause, and the implementation of the indemnity clause itself in real life is missing. So we as a lawyer should come forward and start asking organization to invoke the indemnity. Please invoke the indemnity, let the cost be there. Let us take it to the court. And there are large corporates who have done that, they have been benefited. So let us get into that practice, because if you're fighting for a clause for hours, and then you're running away from the court or from the arbitrator to take over that clause, no point. I move on to Nikunj, and Nikunj is eagerly waiting to answer and give us some thoughts. I'll just also give some angle to it. We spoke about something about cybersecurity. We have a data protection, data privacy act in this place. Lot of things in the cybersecurity, cyber threat, if it is not to do with the system, is linked to data protection and data privacy. If the data is protected and there is a privacy over your data, I think you will be amenable, or you will be totally you can avoid the cybersecurity threat, or as an individual, as an org. So let's take the views from Nikunj on his opinion over the DPDP Act, and how is the interest of the organization, individual, and everyone is being protected.
Yeah, thanks. I mean, before I go to data privacy, I'll have a little bit, one or two topics to discuss for cybersecurity as well. I mean, although it's always external threat, but we also have encountered in last couple of years, we see that our employees are also sharing data outside firewall or an internal environment, and that's a common threat I think majority of the companies are facing. It has started from 2020 with COVID, with what right reasons and all those things, but I think we see that cases also spiking up even after COVID as well. And that's a big challenge, and I'll go back to your point, Nandini, to start. It is about awareness, creation of awareness within the organization as to what is allowed, what is not allowed. Obviously, as far as cybersecurity incidents are concerned, everyone, as you said, gets duped, and therefore they learn the lesson. But as far as this data exploitation cases are concerned, here the companies or the organization are on the receiving end. Right, so employee makes mistake, but data really goes out of the firewall system, and this is what is, I think, it's very important, and compliance professionals are definitely struggling for this kind of a challenges as well. But I think this is what is organization need to put little more efforts into, apart from awareness for sure, number one. And I've seen companies taking stringent action in terms of sanctions also. So, for example, if I may share our best practice, if we have any data exploitation cases coming up for investigation, and if that particular person is being trained already and there are data to suggest that that particular person is trained, I would definitely go for the next level of sanction than to give a warning, for example. Right, because it's known, and even after knowing that, if it's done, I think then we need to move up the ladder in terms of our sanction metrics. So coming to data privacy, as you said, yes, I think we have a law, we have an act, and then we are waiting for the rules. So it's like, the devil in the Mummy movie, if you remember, the skeleton is ready, but flesh is yet to come. So I think we are waiting for the flesh to come, and I think it will come soon, as you all know. But having said that, I think the data protection law is I would say broadly makes a finer balance of the, let's say, interest of individuals as well as businesses, as well as government as well. And this is what clearly is coming from the Act. Definitely it makes individual in a driver's seat in terms of allowing the usage of their personal data. They are the one, it respects their fundamental right of privacy and gives them a lot of power in terms of whether to share the data or not, and if at all to share, when to revise and when to delete. Equally, it casts a lot of obligations on the businesses as well. In terms of the protocols, they need to have it into the system, privacy by design and default as we call it, as also a lot of IT systems as well. So these are very fundamental for businesses to use this personal data. And last but not the least is again government as well. So it also protects, let's say, the interest of government as well. It allows data sharing in instances of national importance or national security cases as well, as also cross-border data sharing as well. So there are concepts, and I think we are definitely, if I may say, we are highly inspired by GDPR of European Union as well as CCPA of United States as well. But I think we are in right direction. We are, as I said, we are waiting for the flesh and meat to come. But I'll take 2 more minutes there to go to the next level of discussion as to, having said that, what do we really need to do? Do we really need to wait for the act to come, or can we start doing something right now? And I think this is where what organizations are doing, and I think what we should do is to start taking stock of the personal data we are using, which in typical terms called data mapping exercise. And we have seen a lot of organizations are doing that exercise, and frankly speaking, MNCs are also getting surprised with a country like India and the amount of personal data they end up using, without even at some point in time without them realizing that. So this is, I think, the one step organization can really start in terms of being aware about the entire process. There are a lot of, let's say, systems and different ways of handling the data mapping exercise. For example, it can be interview based, but there are also robust system out there which directly gets into your system, get access, and then finally it generates report which gives you where your data lies. So it's a combination of these things, and then based on the budgetary consideration of the company, I think one should definitely start the process if it's not done already. So this is what I think to start with. But yes,
no, absolutely, absolutely right. We have the act, skeleton is there, the flesh is still to seen, but GDPR is there. I think most of the organizations are indirectly impacted by GDPR. He's talk about data mapping. Problem with the organization is there is no data discovery. Where is the data? Which is the data which is important? Is it only Aadhaar and PAN? I think our act, the Indian Data Protection Data Privacy Act, is very far-sighted. They have spoken about consent manager, and believe me, if the act gets implemented in the right direction and the way I read it, the consent managers will be who? Who will be the consent managers? It's not going someone who in the organization. It will be the DigiLocker. A large organization like DigiLocker. You don't have to give your KYC to anyone. DigiLocker will reach out to the person who needs the KYC will reach out to DigiLocker. DigiLocker will reach out to you. Look, central database management system process is being thought through in our act. Probably, and I have seen, is the only getting a tick mark from the individual is a consent? I disagree. And that is what the act is having a vision. Let us see I am waiting to see the flesh of the rules, because the rules need to talk in that direction, and we are seeing lot of things which are happening. The DG Yatra, if you see now the DG Yatra, if you use DG Yatra, they ask you till what time you want this to be there. The time period has become important. So it has already started seeing impact. So it's great to see the act there. The act talks about huge penalties, which should be there, because we as a lawyers are supposed to deter the people, and then again I repeat, again gone are the days there will be penalties. The days are there will be stop doing this. So it takes me to the interesting aspect, and like we were talking about the data discovery part, data mapping part, how the consent managers need to come up. And again, as I said, all of these topics are very vast. The entire day can be spent on these topics, the discussion. But I feel like the data life cycle is key to data protection. And Nikunj, again, I think you being one of the data experts here, the data life cycle is key, the very key to data protection. We need to hear your thoughts over that.
Yeah, I mean, certainly, as I said, I think it starts, and then I'll start with data lifecycle per se, and then about the importance of it. As we discussed, data mapping, data discovery exercise. But having said that, I think in terms of the other aspects to consider, one is obviously data minimization. and purpose limitation as we call it. I think traditionally we don't have that kind of a mindset in terms of handling personal data, frankly speaking, not only at a corporate level but also at an individual personal level as well. We at times we have not been very mindful about our own personal data. I think we have migrated to some extent, and now we are talking about protection of our personal data, and so is the case for corporates as well. So that's why I think this is it's very pertinent to ask this question: do I really need this kind of a data? And in this exercise, I think what is very important is that although DPDP Act, as we know, is limited to digital data only, but I think what we need to take stock of is all data, including physical as well, and ask that do I really need this kind of data? And if not, I think that's the first step to clear that thing and take this redundancy out and therefore create a little less load into the system, as also manage the less risk of managing personal data. The second one is, as you said, Nitin, consent manager as well as data security. So having consent manager, as you discussed already, I won't get into that, but the very next important step is data security management. So you have consent in place, a specific one, freely given, but at the same time, then it becomes your obligation to store the data very securely. And therefore, you need to have a right kind of a digital framework which ensures that your data, whatever you either store or process, is done very securely. And there is no data leak there, because in case of data leak, you are responsible as a corporate as well. So story doesn't end there. I think then comes the next level is about overall data governance. How are the companies managing the data governance piece overall? And therefore comes the topic of having policies and processes and kind of integrated with the system. And for global companies like us, for example, I think we would be end up complying practically each and every data protection law on earth, right from west to east. And this is where I think a robust common system, if at all, we can have. And we have had that discussion. At one point in time, we had more than 5 different systems handling data protection related topics only. And we had a very, very hard time to kind of integrate into one. And I think we are now at a state to say, okay, irrespective of the law applicable, we have one system which takes care of it, and then obviously we then go ahead and modify the nuances at a local level. So I think if we take all these topics together, these are the levers to make this data protection or the data protection implementation and compliance of it is very important. And then comes data lifecycle, because it takes care of the entire piece of, right from getting the data to processing to sharing to deletion. So this entire data lifecycle management, if at all it's handled, let's say perfectly, what we are doing essentially is that we are mitigating a lot of legal risk by just following the data lifecycle management. And even before any application or any proposal, if we go through the data privacy assessment, which is again the requirement of the law, automatically it takes care of the risk involved as also the stock of the risk. So organizations are clearly aware about the risk they are dealing with. So this is one of the topic I think which helps.
That's so true, because all of this is so much connected, and I said I'll make the session interesting, so I'll ask few questions now, and the questions can come otherwise also. How many of you want that your Aadhaar, your PAN should not be asked with you? You want to do something with the government, they ask your identity. Why your identity is checked through documents? How many want to believe in that era that you don't have to share your identity and you have to share? You are sharing it in WhatsApp, you're sharing it in mail, you're going there and giving your hard copy of identity or shares. How many of us want that to happen? I think everyone want that, nobody should come up and ask me, share me your Aadhaar, share my PAN card. Answer to is the consent manager. The consent manager will have your data. Whoever need my data, go to the consent manager, take it. The consent manager will come and ask me. It's one person who's going to deal with me, I can make him accountable. So let us hope, and all of us as an advocate, let us make this as an advocacy to have a very strong consent management system in place. And I take this forum to speak that, because if the strong consent manager will be there, the DG locker, which is a kind of a consent manager, which should be, in my view, or the government has to come forward for that and answer to this, the entire life will become simple, and organizations don't have to struggle for each and every data, because the data which will flow from these consent managers will be encrypted, we will have those security features, we will have those hashtagging, which is not to be worried about.
But Nitin, as organizations who store, process, and use this data are responsible for, taking explicit consent from each customer whose data is being processed.
That's right.
If the customer asks you to delete it, you have to delete it. You have to take, even regulators are telling us to take explicit consent for each activity that you will be carrying out by using that data. Even if it is forming part of a terms and conditions or a privacy policy, which is checked by the customer and is accepted by, still it is insisted that you have tick boxes where he is giving consent for each app permission that you want to go and access, each consent, wherever you are going to use that data, how you are going to process it. So they want tick box for each consent. So that's the expectation here.
That's
so
right.
The responsibility falls on us actually.
That's right. And data privacy policy is there with every organization.
Yeah, and you need to also review all of your contracts. We have now implemented, I want to say at least a year, that we require data privacy, cybersecurity clauses in every single contract that we do with customers. And we get a lot of pushback on this, a tremendous amount of pushback from the business, from the customer in itself. But now that we are in this world where cybercrime is a reality, you as legal have the duty to ensure that you're protecting the company by having these clauses in your agreements.
Yeah,
So
absolutely.
review all of that.
And our responsibility when we are using any third-party service providers who are accessing our data, accessing our customers' data, that is the main source of attack. We have to ensure as host organizations that the security setup that we have is also ensured at the third-party service providers end. There are limitations of budget. There would be limitations of budget at the at the third-party service providers end, but it is our customer data, and the cost of any ransom attack is huge. Their ransomware attacks were earlier individualistic. We know defect technology, how it is hitting us. We even don't get to know whether it is the real person or it is a deep fake. We do a lot of video KYCs these days, and so we need to ensure that at the third-party service providers end also, and we need to conduct proper drills, tests at the premise of the third-party service provider. We need to carry out proper audits, and if there is any data leakage that happens from at the premises or from the server of the third-party service provider, even for that we will be responsible and we will be penalized, or there will be restrictions on us. So we need to be careful. About
Absolutely
that.
right. That's what organizations should get into impact assessment report. Data privacy impact assessment, gap assessment reports are very important. Get the audit done. Probably we'll get to know where the gaps in the organization. As a DPO to my current organization, I have made it very clear, no changes in the data privacy clause unless the request is seems to be very genuine. Otherwise, we have made it clear to the teams that any change in data privacy related clause, where the consent clause has to go through the DPO. So that those checks and controls need to be brought in. And again, as I say, it's now more to do with mails. Things have to move into system. The approval mechanism should also be there into the system itself, wherein who has approved it, what is the change being approved, all that can be tracked. I think we can.
May I ask a question?
Sure, please.
Sure, ma'am.
Since Mr. Manoj was mentioning about audit and other things, so yesterday also we had the session and I asked yesterday also, now today all in general counsel to get just ask this. See, there are companies, there are companies who share their customers' data, I mean our data, especially to the bulk SMS companies. We keep getting SMSs, we keep getting calls also nowadays. Those companies have now gone on to another level, now they are calling us. So what I feel is, and I would like to know about your take on this, is it not possible that whenever there is, after this act is implemented, after the DPDP act is implemented, the people who do not give their consent for any further use of their personal data or whatever data, so is it not possible to have some internal controls itself that would filter those data and because the SMS and all these systems are going to stay, they are not going to go. So when these data are shared by a third party, then those third party will have a filtered list instead of, like we used to have this DND, do not disturb. Despite the fact that I was registered, I was still getting calls, and I used to tell them that you need to check. So now they are not going to check, they are not going to do any due diligence. So the companies who are sharing my data will have a filtered list, and I will be filtered out, and only those people who have given their consent, those data can be. So for this, audit part is also, the IT audit part will become
Absolutely
very
right.
significant.
You're absolutely right. So that's why it needs to form part of the agreement that we execute.
Right.
There, and the explicit consent that I mentioned. So
Right.
unless you as a customer give consent that you allow that third party to share your data with
Right.
any bulk SMS entity, till that time the service provider should not share it. And the simple thing that we should do, I think whenever we enter any society, any mall or any place
Yes.
these days, that is the first source of data leakage. I think
Exactly.
we are missing all that. We
Yes.
provide our name, we provide our address, we provide our mobile number, we provide our email ID also.
Yes.
Because it is asked, so we provide.
And
I
it is
think we should-
mandatory in the part that if we don't, then they don't process.
No, I think that's not the case.
Few companies, they do,
That-
pantaloons, they do.
No, any entity. So you should be very, very clear that you are not
Yes.
ready to share your data because it's your mobile number or whatever.
Yes.
Entry will be given.
Right.
They want to check your identity, that can be checked. But I think you should not. That's the basic
Yes.
list. Bulk SMS वहीं से आते हैं और
Yes.
कहीं से नहीं आते.
And in fact,
वो
what
basic
my
source.
what my
और free
cons-
वाला है, free.
Yes,
500
exactly.
रुपए बिक जाता है.
Exactly. And my concern was, and I would like to have your view on that. Well, why not develop a software that would filter out the data that they don't have the consent,
That's what-
and have only the ones who have the consent.
That's what the impact gap assessment. If you do data privacy gap assessment, will search these gaps.
Right.
The audit itself will answer this. There is a gap, which is the data which is going out to any third party.
Yes.
The person who was actually given you the consent has given you only for 30 days for this
Right.
particular for activity, nothing for else. So all of this is going to aid to it. So
Thank
the,
you.
And
the
as
point
you-
is to get your audit done.
Yeah, as you mentioned, the system will ensure that where there is a consent, only that customer's data will be processed for a particular activity, wherever it is required to
Thank
be
you.
shared.
What our concern was, I think the crackdown can be done through the government only, and I think government is taking direction. I think last week or last week, the government came up with this recommendation. I came up with this recommendation, where what do they call CNAP? Know who is calling you. So they are these telecom operators. They are the TRI is actually working in the direction. They have put out a recommendation. CNAP is called. I don't remember the full form. Huh.
Compliance is not executed because we had DMT also.
No, the regulator in financial services asked to all the banks to implement DPDPA. So when you mean to say asked, it's like prepare the audit report, prepare the gap assessment, present to the board, what is the gap, get that remedied. And if all of this starts happening, again, we started with the point, regulations are there, it need to be practiced, it need to be adopted. I think that can answer.
DPDP rules is still 3-4 months away. It will come after elections, and I think entities will get 1 year's time to implement. So that, and at that time is required. It's not easy to implement. It's a very tough regulation for all of us, for all our entities, and additional regulatory implication on all the entities is on the general counsels and compliance officers.
So with this point, I would like to thank our esteemed panelists for their wonderful insights on this issue. Have a huge round of applause for all our panelists.